everybody, News Now Wyoming here, bringing you another episode. This one is going to be the case of Jack Miller versus the stupid cops. And so this is an order from the court. This is requiring a reply, a 7A reply, which 7A, of course, was that motion to dismiss for qualified immunity. We'll go into exactly what this says and what this means for Jack. This is not a bad thing. This is very typical. So, Jack, I know you watch my videos. Do not be concerned. I waited a week after it was filed to do this video in case your attorney wanted to reach out to you to discuss it with you. Okay, nothing to be concerned about here. This is a very, very standard. So, and I'll talk about what a typical reply is going to show to answer her questions. Okay, my stupid cops have filed an answer asserting the affirmative defense of qualified immunity, docket number 9, which I did cover in a different video. Because greater detail will assist the court in resolving the issue of qualified immunity, Jack Miller is ordered to file a 7A reply no later than 21 days from the issuance of this order. When a public official pleads the affirmative defense of qualified immunity and is answered, the district court, on the official's motion or on its own, require the plaintiff to reply to that defense in detail. District court's discretion not to order a Rule 7A reply is narrow indeed when greater detail may assist. In the 7A reply, the plaintiff must allege with particularity all material facts establishing his right to recovery against each defendant, including facts that support any allegation by the plaintiff that qualified immunity does not bar recovery against the defendants. By definition, a Rule 7A reply must be tailored to the assertion of qualified immunity and fairly engage its allegations. Qualified immunity includes two inquiries. The first question is whether the officer violated a constitutional right. The second question is whether the right at issue was clearly established at the time of the alleged misconduct. Therefore, the reply shall allege facts showing that each defendant violated the plaintiff's constitutional rights. Also, the reply shall define the clearly established law that the defendants are alleged to have violated at an appropriate level of generality and cite reported decisions of the Fifth Circuit or the Supreme Court to support the plaintiff's contentions. No technical forms of pleadings are required in the 7A reply, but the reply shall be simple, concise, and direct. One of the most salient benefits of qualified immunity is protection from pretrial discovery, which is costly, time-consuming, and intrusive. Thus, the court orders that all discovery is stayed until the court resolves the issue of qualified immunity or issues an order authorizing the plaintiff to conduct limited discovery to respond to the qualified immunity issues raised in a motion for summary judgment. Signed, the district judge. Alright, so what this is saying then, to put this in a nutshell, the judge is saying, I don't have enough information in front of me. The original complaint, which is not required to have all this information in it, does not have all the information I need to make a decision about qualified immunity. So the reply is going to be for each defendant here in each charge that you are suing them for, is going to have to say, Weber violated my Fourth Amendment Constitution rights by arresting me for violation of not committing a crime. And then you're going to have to provide case law of the Fifth Circuit, which there's plenty of them out there for the Fifth Circuit. And I went over one or two of them in a previous video, showing that it was clearly established that in Texas you cannot be arrested for failure to ID unless you've been already arrested for another offense. So you're going to have to say these three officers each did this. They all three arrested you, and all three of them violated your rights because they arrested you. All three of them were there. All three of them allowed the arrest. All three of them did place you under arrest. then also for the excessive force claims. They violated my rights against excessive force, and this is how they did it. And then this is the case law that shows why the amount of force used was not necessary. And here, honestly, and I've said it from the beginning, the excessive force are the weaker side to get over for qualified immunity. Doesn't mean they don't exist, but it is harder to overcome. Because even if they arrested you illegally according to case law, any amount of force, in my opinion, hold on. I apologize. So, in my opinion, any amount of force used for a illegal arrest is excessive. That is not what the case law says. So, your attorney is going to have to find Fifth Circuit or Supreme Court cases that shows the amount of force that they used on you with your neck against the cooler and your arms, just all the bad things that they did to arrest you is excessive, and there's going to have to be case law showing that. And so that is the weaker claim. I'm not saying that that's impossible to overcome, because I'm certain that he can find something. I'm just saying that that is the weaker claim, other than the one against your child, or how did your complaint read it? Something about mental harm in front of your kid, or whatever that. I apologize. It's been a while since I read your pleadings, and I've read a lot of cases since then. That one again, in order for that to succeed, he's going to have to bring case law showing that what they did was improper in front of the kid. And so, but that's a state claim and not a federal claim. And they are immune from suit for the state claim, I do believe. So, that one may just get dismissed outright because of that. But, so there we go. We do have an order requiring a reply from from Jack Miller, sorry. And that is due 21 days after the 11th. So, about April 5th-ish? I don't know. Calendars really screw me up, so. No, about April 1st. So, around the beginning of April, we should have a reply from Jack Miller's attorney, or a motion to request more time. So, which is routinely granted. Alright, you guys, let me know what you think in the comments below. Jack, again, do not be concerned with this order. There is nothing to be concerned about here. This is very typical. We see this in about 70% of the cases that I look at. I see the same order here. We just didn't plead enough in the initial complaint, which is not required. You don't need to plead to this level of particularity in the initial complaint. So she's just saying, show me why it shouldn't have, why I shouldn't dismiss the case. That's all this is. Nothing to be concerned about. So, have a great night.